Hello, everyone. Jax West from Stephen Avery Project, Justice with Jax, and MAM Gossip. We are going live. It's still doing the action needed pop ups on there. And now that disappeared. Hopefully, this is working. I have no idea. I have to go on my other page here to pull up. Okay, good. Now there's people commenting, so I know I'm here. Trying to get on. What the frick just popped up over here now? I gotta pull up the decision. Sorry, I'm a little late. From what I read, that I had scrolled to the very bottom of it. Oh my god, this stuff is taking forever. It was looking to me like Stephen's been denied. And the decision is 49 pages long. And I'm just going to read. Okay, it's now saying the too low frame rate, whatever the frick that means. All right. Court of Appeals decision dated and filed July 28, 2021. State of Wisconsin versus Stephen Avery. Appeal from orders of the Circuit Court of Manitowoc County. Angela Suckowitz, judge, affirmed. Before Neubauer, CJ, Riley, PJ, and Davis J. Per curiam, opinions may not be cited in any court of this state as precedent or authority, except for the limited purposes specified in Wisconsin statute rule blah blah. I never read those numbers. Here's the link to as I'm reading this, and as I read it as well, I won't be looking at your comments. And yes, Carol Ann, that's what I said too. I scrolled to the bottom while I was waiting for Jeff to get done with my computer so I could get on, and so I read the last paragraph and saw that he's basically denied. Okay, so I'm just reading this, not a lawyer, so here we go. Per curiam, in 2007, following a jury trial, Stephen A. Avery was convicted of first-degree intentional homicide, party to the crime, and possession of a firearm by a felon. We affirmed his convictions on appeal. The issues in this new case concern collateral proceedings, whether the circuit court erred in denying Avery's Wisconsin statute 974.06 motion and 2 supplemental motions without a hearing, as well as his motions to vacate and for reconsideration of the first of these motions. We hold that Avery's 974.06 motions are insufficient on their face to entitle him to a hearing, and that the circuit court did not erroneously exercise its discretion in denying the motions to vacate and for reconsideration. Accordingly, we affirm. Overview. We previously summarized the facts of this case in our decision on Avery's direct appeal, see State versus Avery. And we will discuss below those facts relevant to his collateral attack on his conviction. But for context, this case began in early November 2005 with the disappearance of Teresa Halbach, a 25-year-old professional photographer. Volunteer searchers found Halbach's RAV4 on the 40-acre site of Avery's Auto Salvage, a salvage yard business where Avery and other family members lived and worked. It was believed that Halbach had photographed vehicles at this site several days earlier per Avery's request. According to state witness Bobby Dassey, the killer, Halbach was last seen walking towards Avery's trailer. After finding the RAV4, police searched the Avery property and, over the course of the next 4 months, discovered and identified evidence including burned bone fragments in and around a burn pit with DNA matching Halbach's, both Avery's and Halbach's blood in the RAV4, the remnants of electronic devices and a camera, the same models as Halbach's, in a burn barrel, Halbach's RAV4 key, spare key, in Avery's bedroom with Avery's DNA on it, Avery's DNA on the hood latch of the RAV4, deposited, the state later claimed, by Avery's sweaty hands, and a bullet and bullet fragments in Avery's garage containing Halbach's DNA. The case was tried over a 5-week period in February and March of 2007. The state's theory was that Avery shot Halbach in the head in his garage and threw her in the cargo area of the RAV4. He then burned the electronics and camera, cremated Halbach in a burn pit, transferred the remains to a burn barrel, and hid the RAV4 until he could crush it in the Avery car crusher. The defense argued that law enforcement was biased against Avery, who was pursuing a wrongful conviction lawsuit against Manitowoc County and the Sheriff's Department, and as a result, planted evidence implicating Avery. The real killer, the defense argued, took advantage of this investigative bias to also plant evidence on the Avery property, once early media publicity made it clear that Avery was a key suspect. The jury found Avery guilty of first-degree intentional homicide and felon in possession of a firearm. The footnote at the bottom of this page says Avery was wrongfully convicted of a 1985 sexual assault and was exonerated in 2003 on the basis of DNA evidence linking the crime to another person. Avery received a life sentence without the possibility of extended supervision. In 2009, Avery commenced his direct appeal by filing a motion for post-conviction relief pursuant to Wisconsin Statute 974.02, requesting a new trial. That motion was denied. Avery appealed, and this court affirmed in the aforementioned decision. In 2013, Avery filed a pro se Wisconsin Statute 974.06 motion, the 2013 motion, requesting a new trial. That motion was denied, and Avery appealed. The appeal was stayed and later dismissed on Avery's motion, shortly after he initiated the post-conviction proceedings that are the subject of this appeal. In 2017, Avery filed the first of the 6 motions that are the subject of this appeal. These motions will be analyzed individually with further discussion of relevant law, but some basic principles apply generally. Wisconsin Statute 974.06 provides a mechanism for vacating, setting aside, or correcting a sentence once the time for direct appeal has passed, on constitutional or jurisdictional grounds, or where, quote, the sentence was in excess of the maximum authorized by law or is otherwise subject to collateral attack, unquote. The footnote on the bottom of this page says, Avery's appeal is from 2 orders: the Circuit Court's October 3, 2017 order denying his June 2017 post-conviction motion, and the court's November 28, 2017 order denying his motions to vacate and for reconsideration of the June 2017 motion. We address these as motions number 1 through 3. After filing his appeal, Avery moved to supplement the appellate record and to stay the appeal and remand in 2 separate motions. We retained jurisdiction and directed Avery to raise his claims to the Circuit Court in the form of supplemental post-conviction motions. We address these as motions 4 and 5. In April 2021, Avery filed a motion to this court to stay his appeal and remand. We have not yet acted on that motion, so we address and decide it as motion number 6. In full, Wisconsin Statute 974.06 states, That's all it says there. Okay. Continuing on to the next page, starts with the word review, in that it requires the defendant to raise all grounds for relief in his or her first post-conviction or appellate motion. Thus, a defendant is normally barred from raising issues in a 974.06 motion that were or could have been raised on direct appeal or in a previous motion. An exception to this rule exists where the defendant can show a sufficient reason for not raising the issue in any prior post-conviction proceeding. Whereas here, a defendant appeals the circuit court's denial of a Wisconsin statute motion without an evidentiary hearing, then the question before us is narrow: whether remand for a hearing is warranted because the circuit court erred in denying the motion on its face. Pursuant to 974.06, the court shall, quote, grant a prompt hearing, unquote, unless, quote, the motion and the files and records of the action conclusively show that the defendant is entitled to no relief, unquote. Our Supreme Court has also determined, however, that a baseline level of specificity, wow, that's a hard one, applies to all post-conviction motions, including those under 974.06. Thus, in order for the reviewing court to meaningfully assess the claim, the defendant must allege, quote, sufficient material facts, example, who, what, where, when, why, and how, that is, that, if true, would entitle the defendant to the relief he or she seeks, unquote. And the footnote says, all grounds for relief available to a person under this section must be raised in the defendant's original, supplemental, or amended motion. Any ground finally adjudicated or not so raised, or knowingly, voluntarily, and intelligently waived in the proceeding that resulted in the conviction or sentence, or in any other proceeding the person has taken to secure relief, may not be the basis of a subsequent motion unless the court finds a ground for relief asserted which for sufficient reason was not asserted or was inadequately raised in the original, supplemental, or amended motion. This requirement promotes finality once the defendant has been convicted and sentenced, quote, minimizes time-consuming post-conviction hearings unless there is a clearly articulated justification for them, unquote, and recognizes that, quote, the pleading and proof burdens have shifted to the defendant in most situations after conviction, unquote. Accordingly, in the context of a 974.06 motion, the defendant must describe with specificity his or her sufficient reason for failing to raise the claim in any earlier proceeding. That is, the defendant must show why his or her claim is not procedurally barred under 974.06. We will further discuss some of the contours of this sufficient reason exception below, but one point bears mentioning here. Ineffective assistance of post-conviction counsel can be, and often is, cited as a reason for the defendant's not bringing some claim on direct appeal. The specificity requirement, however, applies just as much in this context. The defendant cannot merely present legal conclusions, summarily arguing that post-conviction counsel was ineffective for failing to bring the claims he or she now views as meritorious. Instead, to be entitled to a hearing, the defendant must raise sufficient material facts demonstrating prior counsel's ineffectiveness. That is, that counsel was constitutionally deficient and that such performance was prejudicial to the defendant. The note at the bottom says, of course, a defendant is not required to do so when there has been no prior post-conviction proceeding. Importantly, to show deficiency in this context, the defendant must allege sufficient facts showing that his or her new claim is clearly stronger than the claims post-conviction counsel in fact brought. Whether the circuit court erred in not ordering a hearing involves two potential inquiries with separate standards of review. The circuit court must hold a hearing where the motion is sufficient on its face, unless the record as a whole otherwise conclusively demonstrates that the defendant is not entitled to relief. 974.06 motion meets the standard, including whether there is a sufficient reason for overcoming the procedural bar of Escalona Naranjo, is a question of law that we review de novo. If, on the other hand, the motion does not raise sufficient facts, quote, or presents only conclusory allegations, or if the record conclusively demonstrates that defendant is not entitled to relief, unquote, then the circuit court has the discretion to grant or deny a hearing. In such case, we review for an erroneous exercise of discretion. Motion number 1, June 2017 motion. And I'm on page 7 of 49. In August 2016, Avery, now represented by counsel, brought a motion for post-conviction scientific testing. In November 2016, the circuit court granted the motion permitting Avery to conduct independent testing of 9 trial exhibits, 7 samples of bloodstain cuttings, swabs, or blood flakes taken from Halbach's RAV4, Halbach's RAV4 key, and a 1996 sample of Avery's blood. Based largely on the results of this testing and other investigations, Avery filed a Wisconsin Statute 974.06 motion in June 2017, requesting a new trial. His motion raises a number of claims falling into 3 categories for purposes of overcoming the Escalona Naranjo procedural bar. First, Avery alleges that trial counsel was ineffective for failing to fully investigate or present expert testimony in support of his theory that he was framed. Second, he brings several claims again based on alleged Brady violations. Third, he raises claims based on the results of new investigations of a bullet, the hood latch swab of the RAV4, and the RAV4 key, all of which he characterizes as newly discovered evidence. The circuit court found that most of these claims were procedurally barred under Escalona Naranjo because Avery had not alleged a sufficient reason for not raising them in his 2013 motion or on direct appeal. The court further held that the claims based on new scientific tests, when considered in the context of the full record, did not allege sufficient facts that, if true, would entitle Avery to relief. The footnotes at the bottom here says, Avery reframes some of these claims and arguments on appeal, but our review is of the sufficiency of the underlying motion. We analyze the motion on its face, deeming new or newly argued issues forfeited. In addition, some of Avery's claims, such as his allegations of prosecutorial misconduct, are not renewed on appeal. These we deem abandoned and will not discuss. These principles apply to our analysis of Avery's subsequent motions. The court noted that the new report on the bullet, hood latch swab, and key were, quote, equivocal in their conclusions, unquote, and ambiguous. Therefore, given, quote, the totality of evidence submitted at trial, it cannot be said that a reasonable probability exists that a different result would be reached at a new trial based on these reports, unquote. Accordingly, the court denied Avery's motion without a hearing. We review the sufficiency of this motion de novo if we determine that Avery was not entitled to a hearing as a matter of law. We then review the circuit court's decision to deny him a hearing for an erroneous exercise of discretion. The first threshold step in this analysis is determining whether Avery has stated a sufficient reason for not raising these claims in his 2013 motion and on direct appeal. Ineffective assistance of trial counsel. Avery's claims relating to ineffective assistance of trial counsel are not and cannot be based on new or newly disclosed evidence unavailable to trial counsel. By definition, these claims are based on alleged errors of trial counsel, the argument being that Avery was thereby denied his constitutional right to counsel. As with any Wisconsin statute claim, Avery must show that there was a sufficient reason that these claims were not raised on direct appeal and in his 2013 pro se motion. And to establish a sufficient reason for not raising ineffective assistance of trial counsel claims on direct appeal, Avery must show that his new claims are clearly stronger than the claims post-conviction counsel actually brought. We begin by considering whether Avery has shown a sufficient reason for not having raised these claims in his 2013 pro se petition. We then turn to whether Avery has shown a sufficient reason for not raising these claims on direct appeal. It is at this point that the Escalona-Naranjo analysis dovetails with the merits of Avery's ineffective assistance of trial counsel claims, because if his new claims are facially insufficient as a matter of law, then post-conviction counsel cannot have been ineffective for failing to raise them on direct appeal. Therefore, after we analyze the potential procedural bar of the 2013 petition, we turn directly to whether Avery's remaining claims demonstrate a reasonable probability that, but for trial counsel's unprofessional errors, he would not have been convicted at trial. Sufficient reasons for failure to raise the claims in the 2013 motion. At a starting point, although Avery may argue ineffective assistance of post-conviction counsel as a sufficient reason for not raising these claims on direct appeal, the argument is not available to excuse failings in his 2013 motion. That is because Avery did not have a constitutional right to counsel following his direct appeal. As our Supreme Court recently observed, there is no constitutional right to counsel on a collateral attack, and subsequently, the vast majority of Wisconsin Statute 974.06 motions are filed by pro se litigants. The exception would swallow the rule if the mere assertion of pro se status were sufficient to overcome the procedural bar of Escalona-Naranjo. This legal point precludes successive post-conviction motions from turning into something akin to Russian nesting dolls, wherein a litigant can simply allege a continuous series of ineffective assistance of counsel claims to justify previous failures to raise an issue. Instead, where there are successive 974.06 motions, any new motion must be based on something other than ineffective assistance of post-conviction counsel. Avery appears to recognize this point, foregoing any claim based on the mere fact that he was without counsel. Nonetheless, his June 2017 motion largely focuses on the quality of his self-representation, providing the following justification for not raising any of his current claims in his pro se 2013 motion. Quote, "Numerous unique circumstances are present here that provide sufficient reasons the current claims were not previously presented. Mr. Avery had no way of knowing the factual and legal basis for the claims set forth herein. As a learning disabled indigent prisoner, Mr. Avery simply could not have known them. His attempt to file a meritorious pleading was thwarted by his lack of legal knowledge. The current motion is the product of over 1,000 hours of attorney time, hundreds of hours expanded by private investigators, numerous consultations with experts, the expenditure of funds to retain those experts, and more. To expect an indigent prisoner acting pro se to compile a meritorious motion under these circumstances would be unreasonable. Mr. Avery's lack of legal knowledge, cognitive deficiencies, and the complexity of this unique case provide the sufficient reason that the current claim should be addressed on the merits." Unquote. Thus, we construe Avery to offer 6 somewhat overlapping explanations that, taken together, might provide a sufficient reason for not raising his claims in 2013. 1. He was unaware of the legal basis for the claims. 2. He was unaware of the factual basis for the claims. 3. He was acting pro se, which means by himself. 4. He was indigent. 5. He has a learning disability. And 6. This case is particularly complex. These explanations do not justify Avery's failure to bring the majority of his claims. Again, the quality of Avery's representation in his prior motion cannot in and of itself constitute a sufficient reason for not raising an issue earlier. Accordingly, we reject Avery's first argument that he, quote, lacked awareness of the legal basis for a claim, unquote, quote, lack of awareness of the legal basis for a claim, unquote, is a term of art that does not merely mean that Avery was not a lawyer or lacked legal knowledge. Rather, it means that he could not previously have anticipated a change in the substantive law that opened up a new basis for collateral attack. Here, Avery's claims are based on well-settled law. As to reasons 2 through 6, Avery gives us bare-bones factual conclusions, but does not meaningfully explain why the circumstances he describes precluded him from raising most of these issues earlier. Regarding reason 2, unawareness of the factual basis of the claims, Avery does not explain, and we cannot envision, why he did not have all the facts necessary in 2013 to raise these claims, which, after all, are premised on the further investigation of evidence and witnesses known to Avery at the time of trial. As to reason 3, as explained above, a defendant's pro se status standing alone cannot excuse his or her failure to raise claims in a Wisconsin statute 974.06 motion. With one exception, discussed below, Avery's remaining reasons are similarly deficient. Avery simply claims that he has a learning disability and was indigent in 2013, and that his case is complex. He does not cite any law or develop any detailed argument as to why these facts alone or taken together explain his failure to raise these claims. It appears well established from federal habeas law, from which we can borrow, that reasons such as these are not the sort of grounds on which a procedural bar can be avoided. Petitioner's pro se status, borderline mental retardation, and organic brain dysfunction did not provide sufficient cause to excuse procedural default of ineffective assistance claim. Cause must be based on an external impediment. The one exception we will recognize concerns Avery's contention that, on his own, it would have been impossible for him to have undertaken the extensive investigations later carried out by current post-conviction counsel, which resulted in new theories as to how he was framed and additional factual support for previous theories. For example, if Avery believed that forensic testing would have shown that his DNA was planted on the RAV4 key, he, of course, could have raised the issue in his 2013 motion. But to do so without any chance of success, he would have had to allege that post-conviction counsel was ineffective for not raising an ineffective assistance of trial is italicized, counsel claim on that basis. And to succeed on that, the word that is italicized, claim, he would have had to show that this new claim was clearly stronger than those actually brought on direct appeal. Absent forensic testing supporting the basis for such a showing, this would be an all but impossible task. Thus, unique circumstances might exist wherein a pro se defendant is unable to perform or pay for an investigation, but later gains the resources to uncover new material facts and develop alternative theories of the crime, and on that basis can claim a sufficient reason for not previously raising claims based on those theories. We do not perceive the policies underlying Escalona Naranjo, namely the need for finality in litigation, to preclude this result. Indeed, to hold otherwise could unfairly punish defendants who bring post-conviction motions based on all facts known to or reasonably discovered by them. For Escalona Naranjo purposes, claims based on newly conducted investigations, which could not have been previously undertaken, would appear to be little different than claims based on newly discovered evidence, and we will treat them as such in determining whether they are procedurally barred by virtue of Avery's prior pro se post-conviction motion. That said, the majority of Avery's ineffective assistance of trial counsel claims are not based on investigations that Avery, now represented by counsel, was only able to perform. And the footnote says, there are a number of claims, some overlapping, that cannot be said to be based on new scientific or forensic experiments or investigations by Avery's experts, and which we therefore will not address except to list here. Several of these claims relate to issues that Avery's new experts did explore, and which we discuss in more detail below. But the claims in this list are not themselves dependent on the results of new investigations. Several of these claims also appear, superficially, to be based on some new test or experiment, such as a recreation with a key and a bookshelf. But crucially, these claims are not dependent on Avery's ability to hire new experts, spend money on new tests, etc. We are allowing Avery to overcome the procedural bar of his 2013 petition by demonstrating that he did not have the resources to earlier uncover the factual basis for his claims, but this cannot extend to simple experiments or recreations that require no expert contribution and or that could have been easily conducted at some point prior. On the other hand, we have identified 7 claims, all premised on the results of forensic testing, that could conceivably fall in this category, so as to address, as nearly as allowable, the merits of his motion. We will continue that Avery has alleged a sufficient reason for not raising these 7 claims in his 2013 motion. And that's just crazy that they're talking about a 2013 motion now. This is when they're addressing it. These claims are that trial counsel was ineffective for failing to 1. Present a blood spatter expert who would have found that Avery's blood was planted in the RAV4. 2. Present a blood spatter expert who would have found that Halbach was not thrown in the rear of the RAV4 after being fatally injured. 3. Present a blood spatter expert who would have determined that the theory counsel presented in trial as to how Avery's blood was planted in the RAV4 was untenable. 4. Present a trace materials expert who would have found that the RAV4 key recovered from Avery's bedroom was Halbach's subkey or secondary key. 5. Present a DNA expert who would have found that Avery's DNA was planted on the subkey by law enforcement. 6. Present a DNA expert who would have found that Avery's DNA was planted on the RAV4 hood latch. 7. Present a forensic fire expert who would have found that Halbach's body was not burned in Avery's burn pit. And the footnote on this page says these claims are that trial counsel was ineffective for failing to 1. Cross-examine some of the state's expert witnesses instead of retaining their own. 2. Thoroughly investigate other suspects as to identify a suspect meeting the requirements of Denny. 3. Use available evidence supporting the theory that the RAV4 was moved onto Avery's property by the real killer. 4. Investigate Avery's pretrial belief that his blood was taken from blood drippings in his trailer sink and planted in the RAV4. This claim standing alone does not rely on new investigations. We discuss related claims below. 5. Present a DNA expert's opinions about blood being planted in the RAV4. Avery does not indicate that current post-conviction counsel retained such an expert. Counsel did retain a blood spatter expert whose findings form the basis for the other claims discussed below. 6. Demonstrate that Halbach's key was planted in Avery's bedroom by recreating how the key was found. 7. Demonstrate that the RAV4 key found in Avery's trailer was a sub-key or second key, as should have been evident from the 1999 Toyota RAV4 manual. 8. Detect and raise a Fourth Amendment challenge regarding DNA testing that allegedly violated the scope of a search warrant. 9. Investigate a, quote, chain of custody fabrication, unquote, that allegedly allowed enforcement to illegally collect and then plant Avery's DNA on the RAV4 hood latch. We discuss below claims based on the results of experiments on the RAV4 hood latch. 10. Present an expert on police practices and investigations who would have demonstrated errors in the handling of the investigation. 11. Conduct a simple experiment to demonstrate that a witness could not have smelled burning plastic, Halbach's electronics and camera, in Avery's burn barrel, as the witness testified to at trial. And 12. Investigate a variety of topics, all based on evidence known to counsel before trial. Avery also argues that Halbach's ex-boyfriend was the real killer, but he does not present any cognizable claim based on this argument. That is, Avery speculates that the ex-boyfriend meets the Denny legitimate tendency test for introducing trial evidence that a third party committed the crime, but without pointing to any true newly discovered evidence, explaining why trial counsel rendered ineffective assistance during his Denny hearing in this regard, or otherwise demonstrating why such conclusion entitles him to a new trial. I'm now on page 16 of 49. Merits of Avery's claims of ineffective assistance of trial counsel. We now turn to whether Avery's ineffective assistance of trial counsel claims have alleged sufficient material facts, example, who, what, where, when, why, and how, that, if true, would entitle him to the relief he seeks, unquote. Bearing in mind that he is not entitled to a hearing where the record conclusively demonstrates otherwise. In short, Avery must show that a hearing would not be frivolous. Avery cannot make the showing. First, he was wholly failed to demonstrate deficient performance, that trial counsel's, quote, representation fell below an objective standard of reasonableness, unquote, by counsel's not retaining experts similar to those he later retained. Avery apparently assumes that his findings speak for themselves and that given the strength of his later claims, the necessity for such experts should have been obvious at the time of trial. The footnote on that one says, relatedly, Avery fails to demonstrate how the defense strategies that trial counsel did pursue rendered counsel's performance constitutionally deficient. As an example, he points to trial counsel's failure to obtain a blood spatter expert, but does not address why counsel's chosen strategy for explaining the presence of his blood in the RAV4 represented deficient performance, and now this is italicized, at the time of trial. without the benefit of hindsight. This is a repeated shortcoming in Avery's briefing, both to the circuit court and on appeal, and represents exactly the type of Monday morning quarterbacking that we strive to avoid in evaluating a claim of ineffective assistance of counsel. Quote, post-conviction counsel stresses that he would have done differently had he conducted the defense at time of trial. Our court has called this hindsight is better than foresight approach to be Monday morning quarterbacking, and has made clear that ... it is the right of a defendant and trial counsel to select the particular defense from among the alternatives available upon which they elect to rely. Unquote. Judicial scrutiny of counsel's performance must be highly deferential. It is all too tempting for a defendant to second-guess counsel's assistance after conviction or adverse sentence, and it is all too easy for a court examining counsel's defense after it has proved unsuccessful to conclude that a particular act or omission of counsel was unreasonable. Unquote. Now back. It says, we continue with, Avery also assumes, again, without explanation, that any experts retained by trial counsel would have reached the same conclusions as his later experts. But even accepting these premises, Avery has not demonstrated prejudice. That, quote, there is reasonable probability that, but for counsel's unprofessional errors, the result of the proceeding would have been different, unquote. Avery's first three claims concern trial counsel's failure to retain a blood spatter expert. Avery argues in his motion that counsel was ineffective because such an expert would have found that his, quote, blood was planted in the RAV4, unquote. His retained expert's actual findings, however, are not nearly so conclusive. The expert did not conclude that Avery's, quote, blood was planted, unquote, or rule out Avery as the source of the blood. Rather, he determined that the presence of Avery's blood was, quote, consistent with being randomly distributed from a source because his blood is present in some locations but absent in some other reasonably anticipated locations, unquote, and that, quote, the absence of blood stains in these locations is inconsistent with an active bleeder, unquote. The state alleged at trial that Avery's finger was actively bleeding while he was in the RAV4. The expert further determined that the blood stains were consistent with an explanation other than Mr. Avery being in the RAV4 and depositing his blood in these locations with his actively bleeding cut finger. And the post note on that says, for the purpose of this motion, we accept that these conclusions are based on sound methods. It is unclear, however, how this expert determined that a person actively bleeding in the RAV4 would have left a different blood pattern than what was found in Halbach's vehicle. According to the expert's affidavit referenced in the June 2017 motion, he recreated how blood could be taken from Avery's sink and selectively planted in the RAV4. The June 2017 motion states that, presumably some different, quote, blood spatter experiments conducted with actual blood on the subject's middle finger conclusively, I got a middle finger for this, demonstrates that the blood would have been deposited on, unquote, additional locations within the RAV4. That experiment is not described in the referenced affidavit. However, so we do not know the methodology supporting this conclusion. Now I gotta go back. Where is that? Hold. Where the heck is it? Where did I leave off here? That I read that post? There we go. Okay. Certainly, these conclusions tend to support Avery's general theory that he was framed, and their presentation may have been useful at trial. But Avery's burden in a post-conviction motion is not merely to point to helpful evidence, but to show how its introduction at trial could reasonably have led to a different outcome. He cannot meet this burden by misrepresenting the expert's results as demonstrating that he was framed. Absent additional facts or argument, we cannot assume that such measured support for Avery's frame-up theory would have led to an acquittal. Next, Avery argues that counsel was ineffective because a blood spatter expert would have refuted the state's narrative that Halbach was thrown in the rear of the RAV4 after being fatally injured. Avery asserts that, to the contrary, Halbach, quote, was struck on the head after she opened the rear cargo door, unquote, and was then, quote, struck repeatedly by, unquote, a mallet or hammer, without explaining why an alternative finding as to how she was killed supports his theory that he was framed. Third, Avery contends that a blood spatter expert could have advised counsel that its trial strategy for explaining the presence of his blood in the RAV4 was flawed, i.e., that such strategy would have failed to persuade the jury. This assertion is entirely speculative. As a matter of law, such guesswork falls well short of demonstrating ineffective assistance of counsel. Fourth, Avery argues that counsel was ineffective for not retaining a trace materials expert who would have found that the RAV4 key recovered from Avery's bedroom was Halbach's secondary key or subkey. But it is, again, completely speculative to assume that the subkey was therefore planted and not instead that Halbach herself was using her subkey and not her main key on the day of her death. Avery's fifth and sixth claims concern the retention of a DNA expert. According to Avery, such an expert would have determined that his, quote, DNA was planted on the key, unquote, by law enforcement. Avery again misstates the evidence. His expert analyzed DNA from, quote, an exemplar key. Oh my gosh, sorry. Okay. An exemplar key reportedly held by Mr. Avery as if to start a car, i.e., gripped by ungloved fingers for 12 minutes, unquote. The expert determined that 10 times less DNA was deposited on the exemplar key than on the key recovered by law enforcement. The expert further concluded that, quote, if, the dots mean they're removing some content, and if the key was indeed enhanced, i.e. tampered with, then it is likely that some personal item of Mr. Avery's was used for this purpose, unquote, such as, quote, a toothbrush or cigarette butt, unquote. Thus, once again, the findings of Avery's expert are significantly more ambiguous than what is presented in his motion. We have no reason to doubt the truth of these findings, although we note that the expert did not observe Avery holding the key. But simply determining that Avery deposited significantly less DNA in a controlled experiment does not indicate that Avery could not or did not deposit more DNA under other conditions, and it certainly does not demonstrate that law enforcement planted DNA on the key. Thus, even accepting the truth of these new findings, we cannot conclude that there is a reasonable probability that their introduction at trial would have led to a different result. Avery's sixth claim is that counsel was ineffective for not retaining a DNA expert who would have determined that DNA from Avery's sweaty hands, quote, was never deposited by Avery on the RAV4 hood latch, unquote, demonstrating that, quote, Mr. Avery was being framed, unquote. In what is becoming a pattern, Avery has misrepresented the facts. Getting madder. The DNA expert Avery has now hired did not determine that Avery never deposited the DNA and did not state that Avery was framed. Instead, the expert performed a series of experiments on an identical vehicle wherein volunteers opened the hood latch or the car hood using the hood latch. Only 4 of the 15 volunteers deposited DNA, and those 4 deposited significantly less DNA than present in the swab from Halbach's RAV4 hood latch. From this experiment, the expert extrapolated the possibility that law enforcement could have retrieved and relabeled a swab of Avery's groin, which was collected and discarded for exceeding the scope of a search warrant, as coming from the hood latch. The expert admitted, however, that, quote, the convenience of this explanation and the fact that it accounts for the physical findings observed from the analysis, does not prove evidence tampering, and, or more precisely, evidence reassignment, unquote. Thus, again, we are left with facts that, even if true, would not entitle Avery to relief. In a controlled experiment, the minority of volunteers who deposited sweat on the RAV4 deposited significantly less sweat than on the swab recovered by law enforcement. There is no context to these findings, no showing of why Avery, under non-controlled conditions, could not have deposited more sweat than the volunteers, much less any showing that the DNA was therefore planted. Without such context, this evidence is not exculpatory or even particularly relevant, and Avery's attempt to link to the alleged reassignment of his groin swab is wholly unsupported by any facts of record. Avery's seventh and final claim is that trial counsel was ineffective for not presenting a forensic fire expert who would have found that Halbach's, quote, body was not burned in the Avery burn pit, and that her bones were therefore planted, unquote. Avery's cited factual support once again does not live up to the advance billing. His forensic fire expert did state that he, quote, disagreed with the state expert's opinion that the main destruction of the body took place in, unquote, the Avery burn pit. But Avery does not explain why, from his conclusion, it follows that Halbach's remains were planted, because he does not explain why he himself would have been unable to cremate some portion of Halbach's body in another location, including in his burn barrel, where additional bone fragments were found. More important, Avery does not explain where or how prejudice arises, given that his own forensic anthropologist testified to the same conclusion at trial. Avery's expert further concluded that, contrary to the state's theory at trial, Halbach's body could not have been burned to the extent it was burned in only 4 hours. Again, this is a fact without context. At most, presenting such evidence at trial would have enabled the jury to weigh 2 competing expert opinions on how Halbach was cremated. Avery again has presented no reasoned basis for concluding that the outcome of trial would have been different. In sum, the 7 ineffectiveness claims in Avery's June 2017 motion that are based on new investigations fail on the merits. Avery has not shown that trial counsel provided objectively deficient representation by not hiring experts similar to those he later hired. Instead, Avery merely assumes that the need for such experts should have been obvious at the time, based on the later findings of his own experts. These later findings, however, are either equivocal, irrelevant, or both. In addition, Avery has not explained how these findings would have negated or undermined the cumulative effort of the other trial evidence. Thus, Avery has failed to show that, even if all these findings were admitted at trial, the result would have been different. Consequently, Avery has not alleged sufficient material facts entitling him to a hearing on his claims of ineffective assistance of counsel. Next section, and we're on page 22 of 49. Brady violations. Avery argues that the state withheld favorable evidence in its possession in violation of Brady. The first alleges that the state suppressed a voicemail recording that Halbach left on the answering machine of her photography client, whom she met on the same day that she visited Avery's property. Next, he alleges that the state withheld an unedited video of flyover footage of Avery's property and instead released to Avery an edited version with just 3 minutes of footage. Finally, Avery argues that, quote, investigators concealed their knowledge that Halbach's RAV4 was driven onto, unquote, the property of Avery's next door neighbor. Avery does not claim that these alleged Brady violations were unknown and undiscoverable at the time of his 2013 motion or on direct appeal. His given explanation for not raising any of his new claims in 2013 is general and relates to his status as a pro se prisoner litigant. His explanation for not raising his new claims on direct appeal does not reference the Brady claims. Thus, Avery has not overcome the procedural bar of Escalona Naranjo by demonstrating a sufficient reason for not raising his Brady claims earlier. In any case, Avery's 2017 motion does not sufficiently allege any Brady violations. Quote, a defendant has a due process right to any favorable evidence, material either to guilt or to punishment, that is in the state's possession, unquote. A defendant is entitled to a new trial based on the denial of such right by showing that 1. The evidence is favorable to the defendant, either because it is exculpatory or impeaching. 2. The evidence was suppressed by the state, either willfully or inadvertently. And 3. The evidence is material. The standard for materiality is the same as under the prejudice prong of Strickland. Quote, evidence is material only if there is a reasonable probability that, had the evidence been disclosed to the defense, the result of the proceeding would have been different, unquote. Avery has not demonstrated any of the above elements for any of his claims, but what is clearest on its face is that this evidence, where it even exists, is immaterial. Avery's first claim centers on the fact that on the day Halbach visited his property, she left a voicemail that she could not locate the residence of one of her other photography clients, whom she also visited that day. Avery argues that the voicemail has been played. Had this voicemail been played at trial, it would have, quote, refuted the theory that Halbach's final appointment was with Mr. Avery, unquote. At trial, however, the photography client himself testified that after Halbach left the voicemail on the client's answering machine, she found the client's house, took photographs, and left within 15 minutes. Then approximately 20 to 30 minutes after Halbach left the voicemail, as established through her phone records, other witness testimony placed her as driving to and then on Avery's property. The voicemail is therefore consistent with the evidence, which is that Halbach left a voicemail, visited a client, and then visited Avery's property. There is no basis for Avery's assumption that the content of the voicemail would have refuted the state's theory about when or how Halbach was killed. Avery's next claim is that he received an edited version of a flyover video of his property that may have contained favorable evidence. As far as we can tell, this claim is based only on Avery's substantiated belief that a second video must exist because the airplane was in the air for 4 hours, but the video he received was only 3 minutes long. There is no evidence of a Brady violation here because Avery merely speculates that evidence, not even known to exist, was suppressed. Finally, Avery argues that investigators knew but did not disclose to him that Halbach's RAV4 was driven onto the property of Avery's next-door neighbor. It is difficult to follow this argument, but is based on an affidavit from the neighbor who does not state that the RAV4 was on his property, but rather attests to a conversation with law enforcement agents in which they stated their belief as to how Halbach's vehicle was driven onto Avery's property, presumably after Halbach's death, but the agents could have been referring to Halbach's driving route on the day of her death. I just got an email from Melissa Kalyazinski. Avery suggests that the information in the affidavit supports his claim that law enforcement framed him for the crime by driving the RAV4 through the neighbor's property and planting it on his. This argument is unintelligible, and in any case, we cannot perceive any Brady violation. There was no evidence here to suppress, and the facts in the affidavit are so inconsequential. Next section, and we are on page 25 of 49, is titled Newly Discovered Evidence. Finally, Avery raises two claims, and there's a footnote on that. A third claim repackages one of Avery's ineffectiveness claims, arguing that the results of the experiment with the RAV4 hood latch, wherein volunteers touched an identical RAV4, which was then swabbed and tested, constitute newly discovered evidence. Avery cannot have it both ways. Above, we assumed for the purpose of this motion that trial counsel's failure to obtain such results might constitute ineffective assistance of counsel. We will not now analyze a claim based on the premise that these same results were undiscoverable at the time of trial. In any case, it seems evident that trial counsel could have performed this simple experiment, so it is not apparent how the results of this experiment could constitute newly discovered evidence. And now I have to go back to where, okay. Claims based on newly discovered evidence. He contends that, quote, new scientific evidence demonstrates that the damaged bullet, in Mr. Avery's garage was not shot through Halbach's head, causing her death, unquote. He also argues that, according to new tests, the swab labeled as coming from Halbach's hood latch containing Avery's DNA was not, in fact, taken from the hood latch. And the footnote on that, it says the claim is based on different evidence than forming the basis for Avery's ineffective assistance claim on the same issue. All right. In theory, a defendant should be able to more easily overcome the Escalona Naranjo procedural bar when basing claims on newly discovered evidence, which, after all, concern evidence not available in prior proceedings. This is not the case here, however, as is demonstrated by simply turning to the merits of Avery's claims. To obtain a new trial based on newly discovered evidence, a defendant must show that, quote, 1, the evidence was discovered after conviction, 2, the defendant was not negligent in seeking evidence, 3, the evidence is material to an issue in the case, and 4, the evidence is not merely cumulative, unquote. If the defendant meets these criteria, then the circuit court must determine, quote, whether a reasonable probability exists that a different result would be reached in a trial, unquote. To be entitled to a hearing on post-conviction claims of newly discovered evidence, the defendant must allege sufficient material facts satisfying these elements. Avery cannot meet one or more of these elements for either of his claims. As a threshold matter, he has not shown that his purportedly new evidence is in fact new. Avery asserts that the equipment yielding his test results was previously unavailable, was new technology, and or was manufactured in 2016. But aside from these cursory statements, Avery does not address whether technology available at the time of trial could have yielded the same results. And the footnote on that says, for example, the state points out that its trace expert at trial used the exact same technology and performed the same type of experimental analysis on charred bone fragments before trial that Avery's expert performed in 2017. Both experts used a, quote, scanning electron microscope with an energy dispersive X-ray analyzer, unquote, for their analysis. And there is no statement in the affidavit of Avery's expert as to why his test could not have been performed in 2006. Beyond that, Avery's evidence is largely irrelevant. The premise of his first claim is that if the damaged bullet found in his garage did not deliver Halbach's fatal shot to the head, then he could not be the perpetrator. But the state never argued that either of the bullets recovered from Avery's garage killed Halbach. At trial, the state showed that Avery's gun fired the bullet and that the bullet had Halbach's DNA on it. But the state did not argue that this specific bullet entered Halbach's skull or killed her. Nor was it necessary that it do so in order to implicate Avery in her murder. There is nothing to suggest that shots fired into Halbach's skull were the only shots fired at her, or that every bullet fired at her contained skull fragments. There were, after all, 11 casings and only 2 bullets found in the garage. The presence of Halbach's DNA on a bullet found in Avery's garage. Okay, pause. Buting just tweeted. I'll read what Buting's tweet was. Buting says, in a very lengthy opinion, Stephen Avery lost in the Court of Appeals today, but court said he can pursue new claims in a new motion if he meets legal standards. The fight for truth will go on. Okay, the presence of Halbach's DNA on a bullet found in Avery's garage is particularly damning evidence. No, it's not. Regardless of whether it was the bullet that entered her skull, and strongly implicates Avery absent evidence that Halbach's DNA was planted. A supposition that even now Avery has done little to develop. Talk to Rollie Johnson. Oh, you can't. He died. At the very least, Avery's new evidence, if in fact is new, is consistent with the state's theory of the crime. Avery next argues that his expert observed the hood latch swab and determined that, quote, swabs collected from the hood latches of 2 exemplar vehicles, a 2012 RAV4 and a 2007 Volvo S60, each showed a considerable heavier loading of debris, unquote, than the swab from the RAV4 hood latch. The expert apparently reached this result, however, by observation alone, concluding that, quote, whereas particles on the RAV4 hood latch swab, could only be seen with the aid of a microscope, a swab from each exemplar vehicle showed a heavy, dark streak of collected debris and is clearly visible to the unaided eye, unquote. We are left to wonder how new testing methods or equipment could possibly aid this analysis. In any event, the expert did not determine that the purported RAV4 swab, quote, was not used to swab the hood latch, unquote, as Avery claims. Much less that this swab was reassigned or otherwise used to frame Avery. There is no possibility that the presentation of this evidence would have yielded a different trial result. I'm like trying to contain my seething rage. Sorry. Conclusion as to the June 2017 motion. Because Avery has not shown that he is entitled to a hearing on any claim, we review the Circuit Court's denial of a hearing for an erroneous exercise of discretion. We find that the court did not err in this regard. We agree with the court's assessment that, had Avery's unequivocal and ambiguous conclusions been introduced at trial, there would have been no reasonable probability of a different result. The Circuit Court appropriately exercised its discretion. We have given Avery the benefit of several doubts as to why he did not raise these claims earlier. Even considered on the merits, the claims asserted in his June 2017 motion are speculative, conclusory, and in some cases misleading. The Circuit Court did not err in denying these claims without a hearing. Motion number 2, October 2017 motion for relief from order. Three days after the Circuit Court denied his Wisconsin statute motion, Avery filed a motion for relief pursuant to Wisconsin Statute 806.07. The stated basis for the motion was that a month prior to the court's order, defense counsel and prosecutors had agreed to additional testing of Halbach's RAV4 and bones found in the Manitowoc County gravel pit, that the parties had agreed that Avery would amend the June 2017 motion, and that Avery, quote, intended to inform the court that an amended motion would be filed, unquote, but, quote, did not anticipate the court filing its order, quote, unquote, before he could do so. The footnote says, on appeal, Avery implies that the state misled him about the need to inform the Circuit Court of his wish to supplement the June 2017 motion. For example, Avery states, quote, when current post-conviction counsel inquired as to whether the Circuit Court should immediately be informed of the agreement, the prosecutor stated that once he had finalized the scheduling of the RAV4 examination, a stipulated order could be presented to the Circuit Court, unquote. This statement appears to be Avery's counsel's own uncorroborated description of events. There is no basis in the record for this or any related argument that the state misrepresented the post-conviction process. In any case, as the Circuit Court explained, the state cannot determine whether and how motions to the court are amended or supplemented, and Avery had no grounds for assuming otherwise. Moreover, this argument was not presented to the Circuit Court and is thereby forfeited. Accordingly, we address this point no further. The Circuit Court denied the motion, explaining that after receiving the June 2017 motion, quote, no communication, unquote, was made, quote, requesting that the court withhold its final decision or indicating that the original motion was incomplete and would be supplemented, unquote. The court acknowledged that the defense and prosecution might very well have discussed amended the June 2017 motion in anticipation of the court's granting a hearing, but, quote, the court was not informed of any such negotiations until after the final ruling in this matter had been issued. None of the arguments were submitted to the court for its approval until after the final decision was made in the defendant's original motion. It is for the court and not the parties to determine if amendments to motions previously filed will be permitted and to establish scheduling for matters pending before it, Agreement should, Kathleen just tweeted. Kathleen says, not deterred by the appellate court decision. It pointed out the specific doors that are still open for Mr. Avery's quest for freedom. We appreciate the careful review. Hashtag onward, hashtag truth wins. Christopher, if you could get her tweet posted, since I'm still reading all this. Okay. Where was I? Agreements should have been submitted for approval of the court prior to the final. Christopher, what did you just send me? Okay. Yes. Thank you, Christopher. Can you get that posted on Stephen Avery Project and Gossip and all the places? Agreements should have been submitted for approval of the court prior to the final decision on the original motion being reached. The defense cannot try to amend a motion that was filed without reservation only after it receives an adverse ruling, unquote. Wisconsin Statute 806.07 provides that the court, quote, may relieve a party, from a judgment, order, or stipulation for, mistake, inadvertence, surprise, or excusable neglect, unquote. We review the circuit court's decision on a motion for relief under 806.07 for an erroneous exercise of discretion, meaning we will sustain the court's ruling where it applied the appropriate law to the facts on record so as to, quote, achieve a reasoned and reasonable determination, unquote. As explained above, a movant is not entitled to an evidentiary hearing merely because he or she filed a Wisconsin Statute 974.06 motion. In the typical case, the circuit court will evaluate the facial sufficiency of the motion before ordering the state's response or scheduling a hearing. Thus, circuit courts routinely receive and deny 974.06 motions, where there is no basis for a hearing, as one would expect. Courts are not required to, and generally do not, update the movant about when a decision on the motion is forthcoming. Avery appears to acknowledge these basic principles of post-conviction procedure. Nonetheless, he argues that the circuit court erroneously exercised its discretion here because, in denying his motion for relief, it ignored the existence of a 2007 order. And the post note says, the state argues that this argument was forfeited because it was raised for the first time on appeal. We agree that, at the very least, the argument was not well developed below. For completeness, however, we will exercise our discretion to address this argument on the merits. This 2007, quote, order on preservation of blood evidence and independent defense testing, unquote, directs the state to preserve swabs and blood stain samples collected from the RAV4 and containing Avery's DNA, and allows such items to be submitted for independent testing, quote, without further order of this court, unquote. Avery's argument with respect to the 2007 order misses the mark entirely. Even if all of the items the parties contemplated testing in 2017 had been described in this order, the order has no bearing on the presentation, timing, or amendment of any Wisconsin Statute 974.06 motion. The circuit court correctly concluded that it was not required to revisit its decision on the June 2017 motion upon being belatedly informed that Avery wished to amend that motion. Thus, the court did not erroneously exercise its discretion in declining to vacate an order adverse to Avery so as to allow amendment of, quote, a motion that was filed without reservation, unquote. Now we go on to page 31 of 49, and this section is titled Motion Number 3, October 2017 Motion for Reconsideration. Shortly after filing his Wisconsin Statute 806.07 motion, Avery filed a motion to reconsider, and the footnote says, the motion to reconsider was followed by several subsequent supplements in which the motion was revised. For convenience, we discuss these as a single motion. As relevant to this appeal, and that footnote says, in addition to the arguments addressed in this section, Avery's motion for reconsideration argues that the circuit court made manifest errors of fact and law in denying his June 2017 motion. We review the June 2017 motion in the first portion of this decision and conclude that the court did not err, except as noted in this footnote. Therefore, we address in this section only those arguments based on claims of newly discovered evidence. He alleges that newly discovered evidence warrants reconsideration of the court's denial of his June 2017 motion. A party may prevail on a motion for reconsideration by presenting newly discovered evidence, but such motion is not a platform, quote, to introduce new evidence that could have been introduced, unquote, erroneous exercise of discretion standard, unquote. Motion to reconsideration on the basis of new evidence seem to be of doubtful utility in cases like this where the movement is free to file successive motions. Nonetheless, we perceive no legal barrier to Avery's bringing such a motion, and the state does not argue as much, avoiding the procedural bar of Escalona Naranjo. In this context, to be entitled to reconsideration on the basis of newly discovered evidence, the movement must show that the evidence was unknown and not reasonably discoverable when the first 974.06 motion was filed, and that the evidence reasonably relates to those claims brought in the first motion. Alternatively, the movement may simply bring a new 974.06 motion and demonstrate his or her sufficient reason for not raising the claim in the prior 974.06 motion by showing that the evidence underlying that claim was then unknown and not reasonably discoverable. Avery makes no showing in his motion to reconsider as to why he could not, with reasonable diligence, have included this new evidence in his June 2017 motion. Instead, he uses this third motion as a vehicle for raising new claims. None of these claims or evidence, however, have any bearing on the claims raised in the June 2017 motion, so it is unclear which original claims the Circuit Court was being asked to reconsider or why. In any case, the majority of this evidence cannot reasonably be considered unavailable or undiscoverable at the time Avery filed his June 2017 motion. And the footnote on that is like a page long. So let's go on this footnote. Avery's motion for reconsideration raises claims based on evidence that cannot reasonably available and not discoverable through reasonable diligence at the time of the June 2017 motion. Therefore, we will not address these claims further, except to list and briefly discuss them here. These are that 1. The state withheld evidence that Halbach's vehicle was seen on the street days after her disappearance, claim based on 2017 affidavit of witness attesting that in 2005 he observed a vehicle matching a missing persons poster description of Halbach's car and informed law enforcement of that fact, but with no showing that Avery was unable, through reasonable diligence, to discover this information prior to filing the June 2017 motion. 2. Trial and post-conviction counsel were ineffective for not presenting impeachment testimony on key witnesses, or in the alternative, the state violated Avery's right to due process by knowingly using false testimony at trial, claims based on evidence collected at the time of Halbach's disappearance, and presumably known to Avery at the time of trial. With no representation that Avery learned of this evidence only after filing the June 2017 motion, and could not reasonably have discovered it earlier. 3. There is another possible suspect meeting the Denny test, claim based on evidence showing how long it takes to drive away from Avery's property. 4. There is another possible suspect meeting the Denny test, claim based on evidence gathered by examining images found on a computer. Avery states that the computer search was the result of 2017 technology, but does not explain whether technology available earlier would have uncovered these images or why, through reasonable diligence, he could not have uncovered these images prior to filing the June 2017 motion. 5. Alleged Brady violation based on 2005 evidence purportedly withheld concerning who might have had possession of Halbach's day planner after her death. Avery does not explain when he received this evidence or why it was not reasonably discoverable prior to June 2017. 6. There is another possible suspect meeting the Denny test, claim based on statements made to police in 2005 about Avery's sister, and not Avery, requesting that Halbach photograph a car on Avery's property, but with no showing that this evidence was unknown or not unreasonably discoverable prior to June 2017. 7. There is another possible suspect meeting the Denny test based on evidence that Avery's sister attempted to hide files on her computer that might link her son to the crime. This information was reported to the police prior to trial, and Avery does not allege that he was unaware of this evidence at trial or explain why the evidence was reasonably discoverable prior to June 2017. Motion number 3 also contains arguments that are the subject of motion number 4, and which we will therefore discuss in the following section. Because these claims were brought in a motion to reconsider, we conclude only that the Circuit Court did not erroneously exercise its discretion in declining to revisit the June 2017 motion in light of the content of this motion. Neither we nor the Circuit Court have squarely considered whether these claims are procedurally barred under Escalona Naranjo or whether Avery pled sufficient material facts entitling him to a hearing, although our analysis overlaps with the former inquiry. Such consideration would have to come on a separately filed Wisconsin Statute 974.06 motion, and we express no opinion as to whether such claims would be barred in the event such a motion is filed. End of that footnote. Back to the crap. Nor, if we simply treat this motion as a new Wisconsin Statute 974.06 motion, does Avery demonstrate why these claims are not procedurally barred under Escalona Naranjo, setting aside the question of why the claims were not alleged in the June 2017 motion. Avery has not explained why they are not only in the 2013 motion on direct appeal. And that footnote says, on appeal, Avery inexplicably argues, I'm being told I am freezing up like crazy. Video, and I will start a part 2. And maybe that will help.